What are some possible constitutional challenges to a bill or a law? As you can imagine, on occasion, a California statute is challenged in state or federal court as possibly violating the California or the United States constitutions. So, what might be a basis or bases for these constitutional challenges of state enacted statutes? One common basis is vagueness, which essentially means that the statute was not written with a reasonable degree of certainty so that an average citizen can understand the meaning of the statute and how it will be applied. Courts have used descriptions of these unconstitutionally vague statutes with terms such as nearly unintelligible. Another basis is the violation of the state or federal equal protection clauses. For example, at the federal level, it's found in the 14th Amendment to the federal Constitution. And essentially, this constitutional provision prohibits the states from treating different classes of individuals in different ways. Some state constitutions, like California's, also provide express equal protection guarantees. And how it applies to a statute is that, in general, a statute should not draw any distinction based upon different classes of individuals. There's also another basis is the improper delegation of legislative authority to a state agency or department. That can be a basis for a statute to violate the Constitution. In essence, it means that the legislature is prohibited from granting too broad a set of powers to an executive branch agency. So it would amount to an improper delegation. Violating the separation of powers doctrine that is embodied or actually explicitly set forth in Article 3, Section 3 of the California Constitution. It sets forth our three branches of state government and that the powers and duties of each one cannot be exercised by the other. And the legal principle is basically that each branch of state government should be protected from the other branches, possibly usurping their powers. In California, there's also the single subject rule. It applies to both initiatives as well as bills. That sometimes can be a possible basis for a constitutional challenge because the California Constitution prohibits a bill from encompassing more than one subject that's described in the bill's title. Now, to be fair, the term has been broadly defined by the courts, but there have been several appellate court decisions demonstrating instances where this doctrine has in fact been violated by the legislature in enacting a bill. And basically, the purpose of this constitutional prohibition is trying to prevent the combination in a single bill of, perhaps unrelated matters, particularly to prevent log rolling or where you get support by combining individually supported provisions into one omnibus bill. Legislative drafters in California and in all the states obviously should be careful to draft bill provisions and amendments that don't potentially violate the Constitution. Other constitutional challenges to California bills have included eminent domain, the impairment of contracts, the supremacy clause, the due process clause, the First Amendment. The following little sampling I'm going to give you is some US Supreme Court decisions in which California statutes were struck down by the federal courts and the basis for this occurring. In 2018, in the US Supreme Court decision of National Institute of Family and Life Advocates versus Becerra, it struck down a California statute on First Amendment free speech clause grounds. In the 2011 US Supreme Court decision of Brown versus Entertainment Merchants Association, it struck down the California statute also on First Amendment free speech clause grounds. In the 2007 US Supreme Court decision in Parents Involved in Community Schools versus the Seattle School District, it struck down a Washington state statute on Sixth Amendment right to trial by jury grounds. The American Insurance Association versus Garamendi, U.S. Supreme Court decision in 2003, was struck down on Article 2 vesting clause grounds. The U.S. Supreme Court decision in 2003 of Stogner versus California, that California statute was struck down on Article 1, Section 10 ex post facto clause grounds. There was the 2000 decision in the California Democratic Party versus Jones, where the U.S. Supreme Court struck down the statute on First Amendment free speech grounds. There was also a U.S. Supreme Court decision in 2000 affecting a California tax statute that was struck down in the Hunt-Wesson versus Franchise Tax Board decision. It was struck down on Article 1 Commerce Clause basis and also the 14th Amendment Due Process Clause grounds as well. So you can see over the last 2 decades, there have been several U.S. Supreme Court decisions. So on a federal basis, have struck down California statutes, and there have obviously been California appellate court decisions striking down California statutes as well.